No, this isn't the one we have.
All right, this is case D 08392854D. Counsel, your appearances, please.
Good afternoon, Your Honor. Brandon McCoy on behalf of the plaintiff who's present, appearing unbundled 10402.
Good afternoon, Judge Audrey Beeson, 10511, appearing on behalf of Frank Toti, present with the defendant, who is also here.
All right, so everybody's had an opportunity to review the report from Ponzo,
Yes.
and have you guys been served with, are you aware of the motion that was filed just recently? I mean, yesterday.
No.
All right. What?
Yeah, no, it was filed yesterday, but it
Yeah.
hasn't been served.
Okay, well, there's a motion filed yesterday that's scheduled to be heard on January 25th. Anyway, Mr. McCoy, is there anything in the report that you want to draw my attention to?
Yeah, Your Honor. Obviously, we knew that if an interview was done or an assessment, that it would come back negative for mom. That's what the mom has been saying all along, is that dad's been alienating the children from her. What I would point out that the children, I guess, were interviewed for approximately 7 hours total. The plaintiff was interviewed for approximately an hour and a half. My understanding was that this was to be counseling, not some sort of interview/assessment.
Right.
Defendant, on the other hand, insisted that this was an interview and assessment and that counseling wasn't necessary. And so Dr. Ponzo is stuck in the middle, seemingly doing the best that he can. It was pretty clear that this was to be counseling, was our understanding, yet defendant insisted that these were interviews, and so that was the approach that was taken. I don't know that it was proper that.
Well, that's what we've got, so where do we go with it?
Well, Dr. Ponzo recommended counseling, and that's what we thought we
We
were.
also recommended some alteration or flexibility in the timeshare.
Right, and that we would vehemently oppose. Obviously, again, this was for the counseling, not for the interview. And more importantly, the older children were brought into this, and essentially, we don't believe that that was proper, that
I got it, Mr.
18
McCoy.
and
You
21-year-old
don't like it, everything was improper, and
Of
in your
course.
client's mind, it's all Mr. Balle's fault.
Well,
It's all his fault.
I think the court.
He's completely culpable. And you know what? For a period of time, I might have bought into that argument. Okay? Because when we first started this case,
Right,
I mean, he comes in with a huge shadow over him.
and he still has that shadow over him.
But here's where we're at this point in time. We've had these kids interviewed. We've
And it
had
was
them
supposed to be counseling.
counsel. We've had the children interviewed by somebody with the proper credentials who finds that the children's statements are consistent, that there's no indication of any influence, that the children did not present as influenced by coaching or inducements. The children's consistent presentations clearly reflected their own advocacy. There appears to be no indication of alienating practices or coercion and influence as the source of their negative and polarized views.
Right, I read that. And
Okay.
what I stated earlier was that Dr. Ponzo met with Christian once. Trinity wasn't even there. The second time that he met with them, it was Christian and Trinity for approximately 7 hours. So there wasn't an adequate amount of time to even get into specifics and or the underlying issues.
All right,
It was just
well,
pretty much
here's
mom's
what
bad,
we're going to do then.
We knew the interview was going to be
Counsel.
bad. We knew it was going to be bad.
You can raise all your objections at the time of the evidentiary hearing on the change of custody because that's where we're going to have to go. And then you can appeal it to the Supreme Court. You'll get heard by the Court of Appeals, and they'll send it back to me maybe to adjust or something.
I think if we look, we're
Well,
here,
listen, we're
here
done.
on a status
Counsel, we're done looking.
We're here on a status of
We're on a
counseling.
status check.
It's of
I-
counseling.
Counsel, have a seat. Both of you, have a seat. Everybody sit down.
It's
Ma'am?
hearsay. You can't
this court is familiar with your case, okay? This court recognizes,
That he constantly is
ma'am,
not following the
if you
orders.
interrupt me again, I will just send you away and I'll issue an order that you can read about, okay? I mean, however you want to prefer to take your news, let me know. The court is familiar with the case. The court has reviewed the files. This matter came in before the court on a request for sole physical custody. The court did refer the parties out to try and address the needs and concerns of the children. The court intended the parties to engage in counseling. However, it's clear that before counseling can be well defined as for its goals, there had to be some obtaining of the truth that would require some interviews, some time spent with the children, because mom's entire position was dad's alienating the kids, dad's doing things that create all the friction between me and the kids.
My position, Your
Ma'am?
Honor, may I please speak?
No. The court is endowed with powers to modify custody sua sponte if it believes it's in the best interest of the children. Okay? I can do that. Doesn't matter what anybody's position is or anybody cares. The point is, the court has reviewed the therapy. The court has reviewed prior pleadings, and the court is going to make some temporary modifications. I'm sure, Ms. Beeson, that your client wants an immediate change of custody, and he's willing to go to an evidentiary hearing to address those concerns. Correct?
That's correct.
Absolutely. So we're going to have an evidentiary hearing. We're going to have a trial where this report is probably inadmissible. You're going to have to get somebody in here to testify, and you can hire an expert. You can have the kids interviewed by whoever you deem fit. At this point in time, the court's going to open discovery. Both sides can designate it as many and as few experts as they want. Have the children interviewed. Have the children counseled. In the meantime, the court is ordering that the plaintiff engage a counselor or therapist to address her individual issues as set forth in the Ponzo report. She needs to address specifically issues related to the relationship, the animosity she has towards the defendant, and how it's affecting her relationship with the children. And the children will be required to continue with family therapy through Dr. Ali. Dr. Ali should provide family counseling between the children, the younger children, and the mother as well. On a temporary basis, the court finds that it would be in the best interest of the children to modify the schedule. The court, on a temporary basis, without prejudice to either party, is going to award the parties joint legal and joint physical custody. The mother's visitation at this point in time will be each week commencing Friday after school. If there is no school, it will start at 10 a.m. and will continue until Monday at 8 p.m. At the children's discretion, if they decide to spend an extra night, they can stay over the Monday until Tuesday when they're returned to school, or at 10 a.m. That will be the discretion left up to the children. The children should have free and unfettered access to their older siblings and be able to communicate telephonically with either parent when they're in the other parent's care. How much does your client currently pay for child support, Ms. Beasley? Beeson?
$11.60 without the arrears.
And, ma'am, you currently working?
Yes.
And what's your rate of pay?
I make $90 a day
So you're
when needed.
subbing?
Yes.
And so how many days on average are you getting?
Until February 13th, I'll be working when we go back to school every day because it's a vacancy position. Then I'm out and it's just sporadic again,
All right.
unless I can get that.
Now, are you eligible to be hired as a teacher, or you?
No, I had to drop out when he did not pay
But
his.
you were, what were you missing? You were only missing your student teaching credits?
Yes.
Do you have a plan to get those resolved?
Well, I can't live without, this is how this all started. He didn't pay his court-ordered support. I ended up
Thank you,
homeless,
thank-
all of that. And
thank
we're
you,
here
ma'am.
again. So no, I'm not even
Thank you,
making enough
ma'am.
right now to live.
All right. Okay, so dad's child support obligation, based upon the gross income of $6,000, would be $1,500 per month. Mom's, the court is taking an average. If we did $90 a day, if she's averaging 3 days for 75% of the year, it might be a little bit longer than that. We come up with approximately 39 weeks. Come up with a gross monthly income of approximately $1,200 per month. Her child support obligation would be $300. I believe $1,160 is the cap, right? Is that why we're at $1,160?
Well, that was one of the
That was based
issues,
on
Your
3,000.
Honor, is we've never gotten confirmation of his income. This court's only taken testimony from the defendant. He was required to provide pay stubs as well as tax returns, and we still haven't gotten that. So there was an order to show cause that was submitted, that was subsequently sent or rescheduled, kicked down the road. So
All right.
we have no idea what it is.
Child support, based on this calculation, the child support should be set at, did we give him an offset for health insurance or something, Ms. Beeson?
That's what I'm looking for.
The child support's gonna stay at $1,160. The difference.
That was for 3 children. Is what my client's telling
Well,
me.
if you want me to change it, I'll change it to $1,200 a month. That's what I get when I apply the appropriate right for Osmond formula. Commencing in December, it'll be $1,200 a month. The court's continuing to reserve jurisdiction to retroactively modify the child support consistent with true earnings. On or before May 1st of each and every year, both parties will exchange tax returns, completed and unredacted, including any exhibits, schedules, or other attachments, especially 1099s, W-2s, etc. Failure to provide this by May 1st would result in a finding of contempt unless there is a valid and legitimate reason for requesting an extension from the IRS, and in which case the court would continue to withhold retain the right to retroactively modify based on true income potentials.
Your Honor, with all due respect, this was required the last time that we were here.
Counsel, in the last time
before
we were
that.
here, I did retroactively modify his child support based on the income that he provided. And that the ability to retroactively modify continues to be there.
It still doesn't provide it.
I'll open discovery for
You did.
conduct your discovery, find his income. We've got the motion for contempt that's going to be heard on the 25th, and I'm going to address that at that point. I'm going
We
to,
requested this.
counsel, we're going to talk about it again on January 25th, okay?
And probably we won't have it again.
Your discovery's open. Subpoena records. If you need me to sign subpoenas, I'll sign subpoenas. But in looking at their motion, Ms. Beeson, I hope that your client has some document showing that he provided VIN numbers of the vehicles as ordered to the plaintiff. Because if he didn't provide those VIN numbers as ordered on time, then he owes $2,500 in sanctions, 10 days in jail, and his escape clause is to tender those vehicles. But rather than give her a bunch of crummy cars, he says the value is 20 grand. So he either better have proof that he provided the VIN numbers, or bring his toothbrush for a 10-day stay, or bring $20,000 to purge the contempt. The failure to provide proof of income, I don't think that I'm going to find contempt on that one. But it would be nice if he could provide some pay stubs, counsel.
My client just told me his tax returns that he'll be getting to my office, will be getting them. Do you want them, or am I sending them directly to?
And as for the non-payment of support, it wasn't entirely clear in the minutes, but this court intended the sanctions and the contempt for payments that were missed after February 2014. That was when he stated as of that date he was current. Apparently, and they've attached a copy of it to the motion, apparently there's an audit from the district attorney's office that shows about 11 or 12 missed payments during that period of time.
From what date?
After February
From
2014.
February 2014. Now that's when you told me, from February 2014, you told me you've been current.
Yes.
On everything.
Yes.
Their report from the district attorney's office says otherwise. It shows that there's some missed payments. So you're going to want to look at that. You're going to want to go through your checkbook.
Well, I have my bank statements, yeah.
You're going to want to make sure that you can document all
Okay.
that. Okay?
Yeah, I have my own.
All right.
Yeah. I
So
missed the payment. What?
maybe we'll all get lucky. Half of my civil domestic cases are going to be reassigned on January 17th. Maybe you guys will draw the lucky straw and go before Judge Steele. If not, you'll be back here. I'll see you on the 25th. In the meantime, I expect compliance with my orders. Sir, I expect that the children will be with mother on the weekends. I expect that there will be no excuses for them not spending that time with her. Ma'am, you've read the report. I expect that while the children are in your care, you're not going to talk about Dad. Don't mention him. Don't bring him up. Don't look at pictures of him. Don't ask the kids about him. Don't think about him. Spend the time with your children. Because it appears to the court's satisfaction, and I understand, and I'm not telling you don't have reason to have an issue with the defendant. The problem is that problem is now to the point where it's interfering in your relationship with your kids.
The parenting plan hasn't been being followed, and that's where
Well-
the issues are coming from.
Ma'am, there's lots of issues. You've got a report. You need to get in some counseling. We shouldn't have any more issues because we've diagnosed the problem, and the kids should feel loved and supported and paid attention to, and there shouldn't be any more of their picking up on the animosity between you and the defendant. Now, counsel, perhaps your client can fill in some squiggle for me here. That first vehicle, I'm assuming, is a Ram pickup.
No, Chevy.
That's a Chevy.
That's Dr.
Gosh
Henry
dang,
for you.
that is some hellacious handwriting. What's the second one?
GMC Yukon?
GMC Yukon.
Next one?
Ford F-350.
Okay. Now it gets interesting. What's the next one on
It's
there?
a trailer.
Trailer.
Yeah.
Is that what that says?
No, it says McKinsey Dune Chaser.
Dune Chaser.
Yeah.
Okay, so that's a trailer.
Yeah.
And the last one on there?
Let me see. That's the jet ski that we.
That's a
the Kawasaki jet ski.
Kawasaki.
Yeah, that's the one we.
You're telling me that says jet ski somewhere on
That
it?
says Kawasaki jet ski.
Looks
Okay.
like Jebby Eye.
The last part. Is that where the VIN numbers were supposed to go on here?
No, you're just supposed to give the VIN numbers to her
Oh.
or her attorney.
Oh, okay.
So find an email, find something where they were provided.
I even requested it from Toadie's
I
office.
know,
and
I saw
everything.
everything. I saw everything. So there we go.
Your Honor,
Yes, sir.
when you're done, one last issue there was, the last time we were here, or the time before, Toadie's office wasn't present, or the council wanted to appear
Yeah,
telephonically, so there were some
the-
attorney's fees that were deferred.
The amount of $250 is reduced to judgment in your favor for that appearance. But look, you guys aren't the worst case I've got, okay? And all of your problems, well, not all of your problems, a bunch of your problems could be resolved fairly easily, okay? I understand. You have been put in a bad position again and again. There's been non-compliance with the financial orders. We continue to have problems obtaining the appropriate documentation. You've been made homeless. You've lost the lifestyle that you in the family that you thought you had. I understand. The hurt, the anger, I get it. But what you need to realize, and I hope that you can realize, I believe that Dr. Ponzo's pretty accurate here.
I talked to him today. He talked to me about this today.
I think, and this is what happens, kids are perceptive. And even if you're not overtly bad-mouthing dad, they pick up on stuff, okay? I mean, think about it. In a family, you can talk about your mom, you can talk about your dad, but the minute somebody else starts talking about your parents, that ain't right. Because everybody deserves to love their father. Not everybody got a father that's a saint. All of our fathers have issues.
Very flexible.
My father had issues. He ran afoul of the IRS. Okay? I still love my father. I don't like people talking crap about him, even if it's the truth. Kids pick up on that. You need to try and shield them from it. And I get it. I get it that you got serious emotional hurt, and you need to deal with it.
It's just our parenting plan too. It's like it's not being followed and
Well-
it's causing trouble. I'm not getting the
just-
time with my kids.
I just ordered a new schedule, and hopefully, sir, you're gonna explain to them that things are changing. This should address some of their concerns. It's providing you with significant amount of more time with the kids, less time with mom. Hopefully they'll have more time with their siblings. But they need to understand that where they're getting the benefit of this decision, they have to take responsibility. And if they want me to give any credence to their desires, okay, then they need to show that they're mature and they can handle it. And they need to recognize that they have to have the relationship with mom as well.
Understand,
I will not tolerate, at this point, you taking a position, well, hey, I don't have to do anything. It's her problem. Screw her. Because you want to be the primary custodian. And even if you want to be the joint physical custodian, you're going to have to step up. You're going to have to make sure that you apply the appropriate parenting to ensure that she's getting her time and that things are being handled appropriately. I think, ma'am, that your relationship with the children could quickly and easily be fixed by an outpouring of love and affection for them and a cessation of hostilities, at least while they're around, between you and him. And I get it, it's hard, and I know there's things going on.
I didn't even see my daughter for my Christmas visitation because he didn't
But-
have her ready to go. This is what I'm saying. It's
And
not
this is what
me.
I'm saying.
It's not me.
You can't dwell in the past, even if it's only last week. All right?
It's his daily.
It has to be focused on the future. And I'm beginning to wonder whether or not you're going to be capable of doing it. Because the minute your kids get there, if you start talking about missing Christmas and you start talking about what went wrong and everything that's screwed up in life, you're putting these kids in a position they don't want to be in.
I mean, I didn't even tell him we were coming to court. He discussed that with them last night. That's not okay. They're being drug into this, and it's not by me, really.
I hope you got the VIN numbers.
I have them.
Well, I hope you provided them and you can document it.
Don't think that I did. I didn't know I was supposed to. I never read that. I thought that was what you wanted. I have the VIN numbers. I can get them. You want them on everything, even the jet ski and everything?
You might want to start talking to Mr. McCoy about reaching some kind of a resolution on that issue, because the order was very clear and specific, and there were date timelines provided. So you guys might want to start working on that resolution. Of all the claims, that's the one,
Yeah, I
that
don't
one and
recall that.
the payment of the support.
Well, and actually, Mr. McCoy
Right,
just said everything
so-
should be done with his client. so-
January 25th, we'll see you back here. Until then, get in the counseling. I mean, if nothing else, work on some communication issues with the kids. Figure out ways to involve them more in your household and try and
That's what I
avoid.
mean. If they were there, I could, but
Oh,
that's
they're
what I
gonna
mean.
be there Friday.
With respect to counseling, Your Honor, in the past, it's been ordered that dad pay for the counseling. I just want it clear who's gonna be covering that.
Well, the counseling for the children will be, at this point in time, the court will require him to pay for the counseling for the kids, any of the time that, actually, they're gonna split it. They gotta split the counseling 50-50.
Judge, if I may mention something,
Yeah,
he had to pay over 2,000 to Ponzo.
right.
He had to borrow that. He doesn't have the funds to pay additional child support, plus he's got to pay back the 2,000 for Ponzo, plus counseling for her and the
Well, he's
children.
not paying for counseling for her. She's paying for her therapy, and she's splitting the children's therapy. As for Ponzo, put it in your opposition, and we'll be back here on the 25th,
Yeah,
and we'll address it.
And at
All right.
that time, you'll set an evidentiary if we're back with you,
That
right?
time, if there's not an agreement between the parties, we'll set an evidentiary, or maybe Judge Steele will. But that's the intent of the court, is to set an evidentiary hearing at that time.
at his girlfriend's house.
Right,
they
good
have
luck,
no
folks.
bedroom, no nothing.
I guess, where are the children staying? My
Yes.
understanding is they're at the girlfriend's house,
Yeah,
and
this
that there's
is,
no room for them, no bedroom.
there's a
Call the
couch.
cops, call CPS.
I did that,
No,
Your Honor.
go, 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 go. We'll see you on the 25th. Obviously,
And if they're not there, what do I do? I've been trying to do that for the past year.
That's what I deal with.
Judge, if I may approach on that.
sure.
Yeah, stay in.